Thank you all for coming. I appreciate it's early. I'd like to introduce Gary Blake Casey and Paul de la Piquerie of Selborne Chambers. Gary has a wide practice covering all aspects of property law, as well as property damage, professional negligence and civil fraud. He recently appeared in the Dreambar case, Gibbs and Lakeside Developments, and De Vere and London Borough of Hounslow, which concern the mooring of houseboats. Paul acts in a variety of property and commercial law cases, and most recently in a number of 1954 Act lease renewals and residential disputes in the County Court, High Court and the First Tier Tribunal. Gary and Paul were recently acted in the Tejani and Fitzroy Place Residential Ltd case, acting for the defendant landlord. The claim was in excess of £4 million and was essentially for private nuisance, quiet enjoyment and a breach of the development contract. I won't go into too much detail on the facts, as I know Paul's going to speak about it, so I'll hand over to Gary and Paul now.
Thank you very much. Well, good morning, everybody. I was actually expecting us all to perhaps be sort of around the table rather than sort of lecturing here. But what I'd like to do, I'm just going to say a few words of introduction. And what would be great is if anybody's got any thoughts, I mean, don't fear, there's no pressure at all. If you've got any thoughts about these ideas of, you know, what we want to talk about and sort of develop as we go along, just feel free to just chip in. It's not really, you know, we're not here. It's not a university lecture or anything like that. What are we going to talk about today? Well, I'm going to actually hand over to Paul shortly, who's going to give us an introduction as to some of the legal remedies and how really the law works if you're dealing either for a landlord or for a tenant in this sort of development situation. What sort of legal principles do you need to be thinking about? So that's going to be sort of stage one. Stage two is what I'm going to do, and I'm going to talk about is how the law has developed over the last sort of 20 years or so in dealing with concepts, which is really at the heart of this, the concept of reasonableness. Because what are we actually really looking at? We're looking at the way there is the interaction between the landlord's interests and the landlord's rights to be able to construct a development, maybe putting on an extra level of their building, maybe they're just redeveloping part of the building, and the tenant who is there, their own interests, and of course particularly their covenant of quiet enjoyment. And what's that interaction between those two, and how do those interact, and how does the court manage to balance those two competing interests? And that's really what I'm going to then talk about. And then we're going to go on, and actually Paul will talk a bit about the Tejani case that we were in together. Thankfully, very, very successfully, not for Mr. Tejani, but for Fitzroy. And also we're going to really then talk about really some practical tips about if you're acting either for the landlord, developer, or the tenant, how to either stop there being at a very early stage, how to stop a problem from developing, or if there is a problem, how are you actually going to approach those particular issues. So we can ignore all that. There's a whole load of blurb here. Right, so over to Paul. What sort of things might be a nuisance? Because if we can't recognise what we're actually talking about, how do we know where we're actually going to start?
First of all, let me reiterate Gary's thanks for coming along this morning. We appreciate the invitation. As Gary said, the first thing I think is worth doing is considering briefly what sort of issues do arise between landlords and tenants. A typical scenario is one which I've cited here, which is one in which a landlord might choose to undertake development work, say, to the exterior of the building. And we often find this gives rise to a series of problems. For example, the tenant might complain quite sensibly about the noise that's being made from the works. The works quite often cause dust or various other forms of actual physical damage to the tenant's premises. You can quite often find that there is a smell problem caused by works that are being done. And one often finds with commercial tenants that they suggest that as a result of what's happening, they are making less money. We also typically find that landlords ask for access to the premises in order to actually assist them in their works. And as Gary will go on to elaborate later, this gives rise to the question, well, how much access is appropriate access? What is reasonable, etc. The potential causes of action which typically arise out of these sorts of works begin, I think, with perhaps the most obvious, which is the breach of covenant for the tenant's quiet enjoyment. We also have derogation from grant. It's very rare to have a case in which one might assert a breach of covenant for quiet enjoyment without adding derogation from grant. The two typically go together, and indeed, according to some academics, really should be regarded fundamentally as the same. Negligence is an idea which is also sometimes alleged, although as I'll elaborate briefly upon in a moment, it's not always as obvious as some tenants seem to think it is. The Defective Premises Act 1972 can come into play, although because that relates mainly to injuries suffered by people on the premises, it's perhaps one of the less likely causes of action in the sorts of scenarios that we're addressing today, but it's always worth consideration. And then nuisance, which was in the main subject of our Tejani case last year, which I'll speak to in a moment. I've said at the bottom there that it's also worth considering whether there are actually other covenants in the lease which might come into play. For example, you may well find, especially I think with a commercial lease, that there is a covenant which provides for the situation in which the landlord wants to undertake work to retain premises. It's always worth looking at it because it may actually address the circumstances in which the landlord is entitled to ask the tenant for access and the extent to which the landlord is able to lawfully interfere with the tenant's business. And even if it's not breached, it's worth considering because when we come on to nuisance and the idea of reasonableness, one of the things that I think a judge might sensibly take into consideration when determining whether what the landlord's done is reasonable or not is the extent to which they are actually able to achieve what they're trying to achieve by cooperating with the tenant under a covenant such as one to permit entry. So I'll go through each of those causes of action just to establish a few legal basics. The covenant for quiet enjoyment is usually express. It would be a rare lease that didn't have an express covenant, but even if it didn't, there would be an implied covenant. It is not a covenant that deals simply with noise, although noise is often one of the things that is cited as a breach. There does not need to be physical interference with the tenant's premises in order for there to actually be a breach. Slightly curiously, to my mind, there was for some years various judicial dicta to the effect that that might be something that was required. But that idea has now been cleared up. It was cleared up about 20 years ago by the Court of Appeal. The real point is that it is a covenant under which the tenant is supposed to be, quote, put in possession of the demised premises. And by that, I don't, of course, simply mean literal possession. I mean that they must be able to actually enjoy that which they've been given, leading to the classic statement, I think, of Lord Millet. The covenant is broken if the landlord or someone claiming under him does anything that substantially interferes with either the tenant's title or possession of the demised premises. It is worth noting that an omission, a failure by a landlord to do something, can only be said sensibly to be a breach of the covenant for quiet enjoyment if the landlord actually owes the tenant somehow a duty to do the thing that they have not done. And I've given the example there of a failure to repair. It's not good enough for a tenant to say, well, you haven't actually repaired the exterior of the building, and as a result of this, I'm suffering a nuisance, unless there is actually a landlord's covenant to repair. That was one of the points that cropped up in our Tejani case. One of the allegations made by the tenant was that by failing to remedy the noise on the exterior of the building, the landlord was in breach of covenant for quiet enjoyment. And the answer to that was that that was wrong, because the repairing covenant in respect of the exterior of the building was not actually a covenant given by the landlord. It was a covenant given by a managing agent under the tenant's lease, and the tenant had not sued the managing agent. I think it's always worth remembering that. We also have clarification that now that an act before the start of the tenancy can't be a breach. Again, an idea that almost cropped up in Tejani. A flat was bought off plan, and it was tentatively suggested that somehow the landlord might have been in breach before the actual beginning of the tenancy itself. It doesn't work. It is not a covenant to improve or to repair, and it's certainly not a covenant of indemnity. The reason I've set that out again is I think it's quite a common mistake for tenants to think that a covenant for quiet enjoyment actually requires the landlord to go way above and beyond that, which it really does. And often the answer to that is simply no, you, the tenant, take the premises as you find them. Derogation from grant is very similar. The basic principle, I would say, really is the same. It is that a man cannot give with one hand and take away with the other. Again, Lord Millet. And then we go to negligence. And the starting point with negligence is that there is no general rule that a landlord owes their tenant a duty of care. It can be said that the landlord owes the tenant a duty of care, and typically the situation in which a tenant might say that would be where the landlord retains adjoining premises. And it can be said with force, and it would be right, that the landlord owes a duty to make sure that the retained premises do not cause damage to the demised premises. But there is quite, I think, an important point here, which is that whilst traditionally that was regarded as a tortious duty of care in negligence, it's now actually seen as an implied term in the lease itself. And on the one hand, that is perhaps unhelpful, because I would suggest that often the legal test for the implication of such a term might be harder to satisfy than the legal test for establishing a tortious duty of care. But on the other hand, it carries with it certain benefits to a tenant. For example, it then means that pure economic loss is recoverable, which of course otherwise wouldn't be the case. And then my final bullet point there, yes, a landlord can be liable to a tenant for defects in premises constructed by the landlord. That is a negligence. That would be a negligence claim. But it would only be for actual damage or personal injury. And again, as I say, because that is a tortious claim, that would not be a means by which a tenant could recover pure economic loss. I've cited Section 4 of the Defective Premises Act. It is, as I say, I think less likely to be relevant, but always worth checking, because it relates, as I say, to personal injury, and it also requires the claimant to establish that there is actually a defect in the premises, which is a slightly different burden to simply establishing that some aspect of the premises causes a nuisance, and I think slightly harder. But I've put it up for the sake of completeness. And then we go to nuisance. The leading recent authority on it is Fern and the Board of Trustees, the Supreme Court decision from a year or so ago. That was a decision which I know is being cited by quite a lot of property lawyers as having somehow altered the law of nuisance. I'm not really sure it did, but I think it did provide some clarification and certainly a useful summary of the basic principles. I've actually begun this slide, as I think the Supreme Court did, by citing Coventry and Lawrence, a very good short explanation of exactly what nuisance requires, an unreasonable interference with the claimant's enjoyment of his land. I also want to draw attention to the fact that, as per the second bullet point, it's a tort to land, not actually a tort to the individual. And that is why we have the historic case law as to what sort of interest is required in order for somebody to actually bring an action in nuisance. That is the reason why that question has been asked. It is also relevant to damages, as we'll see at the end of my section of the talk. the fact that it is a tort to land rather than the person means that unliquidated damages are calculated in a rather different way to that which some people mistakenly think. Anything can be a nuisance. There was a tentative suggestion that there was a limited class of things that could be. That's wrong. The claimant, when considering whether or not their enjoyment of their land has been interfered with, is always assessed objectively. One is not allowed to bring a claim if one seeks to rely upon dainty modes of living, was the old quote. The claimant's use, in order to run the argument that their enjoyment is being interfered with, the claimant's use of their land must be an ordinary use. And then one looks at what the defendant is doing on their lands. And this is an important point, which again is occasionally still got wrong. If the defendant's use of their land is ordinary, which very often it will be, then they can still be liable if the way that they're doing it is not, quote, conveniently done. I still see cases in which parties wrongly say that because what they are doing on their property is an ordinary use, it cannot be the case that they are liable in nuisance to the adjoining landowner, and that is simply wrong. And the classic example of this would be if you and I had adjoining flats and I watched the telly in my flat. That, of course, is perfectly ordinary. But if I push the telly up against the wall, turn the volume up and watch it at 4 o'clock in the morning, then it's not.
There was a recent case I saw in the last couple of weeks at Central London County Court about people walking on the floor. Yeah. So again, that's another sort of example of that.
Paul, sorry, since Gary's interrupted, can I carry on?
Yes.
Claimant's use must be an ordinary use. What if it's an illegal use, a contractually illegal use? So is it about the physicalities, if you like, as opposed to the technical, legally entitled or acceptable use? So that, just to be extreme, flat is now used for, I don't know, an office or something like that. It might be an ordinary use of physical space. Planning might allow that, for example, but it might be an illegal use under a lease.
Yes,
ordinary use.
It's a very good question. I suspect that such a claim would fail. If nothing else, it's unattractive. I struggle with the idea that you could describe it as an ordinary use if your contract says that you should be doing something else, or expressly if your contract says that you shouldn't be doing that.
I think a remedy would be different. You know, I mean, isn't that the point? Is that's the breach of covenant rather than I'm not sure that the fact that somebody writes into a lease that, you know, A can't do something that one might think is an ordinary use is going to have that sort of alchemy of turning it into something that ordinarily would be acceptable, but then becomes actually a nuisance because it's a breach of covenant.
It would be a Duval thing, wouldn't it?
Sorry?
It would be a Duval thing.
Well, yes.
Yeah, but I was thinking perhaps of Coventry and Morris, where we're talking about a motor racing track and residential premises. And I was thinking actually, you know, geographically, a long way apart elsewhere, but some residential premises I've been dealing with where within them there's a recording studio.
Yes.
And that actually is a legal use in the lease.
Yeah.
Is it an ordinary use?
Yeah.
That's a different point, but it's, you know, you can see circumstances where something that was a flat becomes that use is affected, but it could still be an ordinary use.
The underlying principle, as Gary said, is this idea of give and take and reasonableness. Again, a case establishing one of the classic basic principles is Sturgis and Bridgman. One of the things that one takes into account when judging what is the common and ordinary use of land in a nuisance claim is the character of the locality. For example, if it is a particularly noisy locality, then a claimant would find it harder to establish that they are suffering a noise nuisance. My second bullet point there was also reiterated by the Supreme Court. In principle, anyone can build whatever they like on their land, with the result that it's not enough simply to say, for example, that an adjoining landowner has built something such as to interfere with the passage of light into your own premises. In principle, that is permitted. One then goes on to ask whether the way that it has been done is somehow unreasonable. And again, we end up asking the question, is what has been done conveniently done? By which what is meant is, can it be said that all reasonable and proper steps have been taken to ensure that no undue inconvenience is caused to neighbours? With that in mind, I'm going to hand back over to Gary, who's going to take you through some recent decisions which elaborate these principles.
So this is my first slide here, just shows a restaurant, because the first case is, well, I can describe that as a restaurant. So I couldn't find anything else. A restaurant that's sort of under some scaffolding and wrapped up, because the first case that I want to talk about is Gold Mile, 20 years ago, Gold Mile Properties and Lecoritis. Now, there, the landlord let premises of a restaurant. Lease has an express covenant for quiet enjoyment, and the landlord covenants to carry out services at the property, cleaning, repairing, those sort of things. The landlord carries out repairs to the walls, to the windows, and they put up scaffolding and sheeting. And what the restaurant and those people who visited the restaurant were complaining about was that it effectively looked as if the restaurant was closed. And even within the restaurant, if you got in there and decided to go in, the restaurant was dark and dusty. I should actually say I had to visit a coffee shop last week where my client is suffering a very similar sort of problem. Scaffolding around the property, and when you see that, you actually kind of realize how intrusive that can be, and the public will often just shy away from going in, and they just sort of see that and think, oh, it's closed, it's sort of under wraps. So that was the problem. So this is one of those cases that starts off at a very low district judge level. It then goes all the way up to the Court of Appeal. The district judge, in trying to exercise and work out that balance between the covenant of quiet enjoyment and the covenant to be able to carry out the works and the maintenance, said that the landlord had taken all reasonable steps to minimize risk from the works. Goes on then a first appeal to the circuit judge. Circuit judge says no, the landlord would be in breach if it had not taken all possible steps to minimize disturbance to the tenant. Well, that went off then on a second appeal to the Court of Appeal. The Court of Appeal reversed that decision, and the Court of Appeal said that, firstly, when the parties signed the lease, it would have been apparent to the tenant that the tenant's enjoyment might be made temporarily less quiet as a result of the carrying out of structural repairs. So just pausing there, I think one of the lessons to take from that is what did the tenant know? What was the tenant told at the time that they enter into the lease? Because I think that is sometimes could be a critical factor in cases of this nature. The court said that the landlord had acted reasonably, and they let me just see if I've actually got the actual quote in my notes. They overturned the decision, and Lord Justice Sedley dealt with the principles of reasonableness and noted that before embarking on the works, the landlord had actually sent the tenant an estimate that had been challenged. The and said that it would interfere with Christmas trade. The works were postponed by 6 months, and the cost was deferred through the service charge to be spent through the whole year. Now, what Lord Justice Sedley then went on is the quote that I've actually got then on the screen. It's perfectly possible, at least in principle, to make provision in a lease to cover the kind of disruption which has occurred here. Now, pausing there, I don't know how many people really ever see that, because whenever I've given this talk before, actually no one. I think I had once somebody said, "Oh, I have seen a provision of this nature," but it's very rare. So most of the time, you wouldn't have something that says, "Well, my right trumps yours," and you know, we're going to be able to carry out those works. He then goes on to say, in its absence, well, that's going to be the majority of situations, while there is no obligation or necessity to reflect the disturbance of quiet enjoyment by remitting rental service charges, an offer to do so may well help in establishing the overall reasonableness of the lessor's intervention. And here we see the genesis of this concept that I'm going to kind of develop in the next 10 minutes or so, as we see in other cases, that either a complete waiver of rent, 100%, or a reduction in rent has this kind of magic that can turn what could be a breach of quiet enjoyment or a nuisance into something that the tenant is left actually without a remedy, because in terms of the balance and the reasonableness, the court is saying that actually the landlord has acted reasonably towards the tenant. So again, just hold that in your mind. We move on then to Century Projects and Alman Qatar. This is a case about Centrepoint in central London. And the tenant at the top of Centrepoint sought an interim injunction restraining the landlord carrying out works to the concrete facade. And it's all about the how they were actually going to do this. I think everyone accepted works had to be done. It was all really about the method. And the tenant, again, sorry, I should say, final bullet there, you've got the two covenants. You've got the express covenant, and you've got then the repairing obligations. Now, what was interesting here is that the contractor had considered 6 different methods of access and concluded, having gone through that exercise, that traditional scaffolding was the only viable option. They looked at sort of those where you have cradles suspended and various other things, but they said we had to put up this. Now, interim injunction application before Mr. Justice Nugee, as he then was, and the tenant argued that the landlord was not taking all reasonable steps. Again, we're back to where is the test. Now, what Mr. Justice Nugee said, I'd have no difficulty in accepting that where a landlord has let premises for a particular purpose, the lease contains both a covenant for quiet enjoyment and an obligation on the landlord to do repairs, neither provision trumps the other. The way the two provisions fit together is that the landlord can carry out work provided he acts reasonably in the exercise of his right. And let me just, I think there, he, I think, really found and developed the principle in Goldmile of Lord Justice Sedley that reasonableness is the touchstone. And what he actually said was that in the circumstances, it seems to me that the claimant faces a very uphill task in establishing that the landlords, in following the consistent advice of their contractors, civil engineers, structural engineers, would be acting in breach of covenant. If the test is one of reasonableness, I find it difficult to accept the court at trial would find the landlords to have acted unreasonably in these circumstances, whether or not it finds the expert's proposal, in fact, a viable one. It's the landlords who have to place the contracts, with the help, no doubt, of their professional advisors, devise and supervise the necessary works. So I think really, again, just so we see in the first case the principle that I wanted to really take there is this idea, the first idea that money, in terms of what the landlord can offer the tenant, can make a significant difference. I think in Century projects, it goes a stage further in that the key point here is that the landlord hasn't just rushed off and said, right, this is the only way we can do the works. The landlord's actually paused and gone off and looked at 6 different types and methods of perhaps carrying out this work. I mean, one might say that's an incredible exercise to have gone through. But it's quite clear that Mr. Justice Nugee was very persuaded by the fact that they'd done that and come to a conclusion which seemed a perfectly reasonable one. So let's just develop this finally in terms of these principles to Timothy Taylor. Now this is the problem. This was the actual Timothy Taylor gallery, and you can see why Timothy Taylor wasn't very happy. As I say, I've said, is anyone there? Again, I mean, you really would be going along there in Mayfair and thinking, I want to buy my very expensive painting and artwork, but I don't know where to go. And what the landlord there was doing was building on extra floors onto the building. And so Timothy Taylor, commercial art gallery on the ground floor in the basement, 5-floor building in Mayfair, and you've got apartments from the first floor upwards. The landlord is carrying out a substantial development to the interior and putting extra floors and new apartments in there. And the tenant complained about the noisy building works, the scaffolding that was wrapped around the building. So it isn't, in this case, it's not just about noise. It's about dust. It's about all the scaffolding. It's all of those sort of things all together. Here are the legal principles. So the landlord's reservation should be construed as entitling the landlord to do the work contemplated by the reservation, provided that in doing that work, it's taken all reasonable steps to minimize the disturbance to the tenant. Secondly, it's relevant what knowledge or notice the tenant had at the commencement of the lease. That's the point I made a few minutes ago. Were they aware that the landlord was going to be carrying out those works? And then finally, and importantly, back to the gold mile point, an offer by the landlord of financial compensation to the tenant to compensate tenant for the disturbance is a factor which the court is entitled to take into account when looking at overall reasonableness. And again, it's this magic that suddenly I'm the landlord, I offer the tenant 50% of the rent waiver for the period of the year that the works is going to be carried out, and suddenly what could have been unreasonable is suddenly reasonable. Now, this is what Alan Steinfeld says. In a case whereas here the landlord is exercising its reserved right to do works entirely for its own purposes, and where the carrying out of those works whilst profiting the landlord confers little or no benefit on the tenant, it seems to me that this, and that's the money factor, is a factor which the court is entitled to take into account when viewing the reasonableness of what the landlord is doing. Now, before I go on to I'm going to talk about the scaffolding and about the noise. Yes, Paul.
Isn't what the judge actually saying that this is whether what the landlord is doing is carrying out repairs, so an obligation, or whether the landlord's doing it for its own benefit. Yeah. So
what you've just preempted me actually over there, because what I was just going to say to everyone is I think the best way of looking at this is in a spectrum. And on the one end, you've got the landlord who's very obviously carrying out repairs to the building or the common parts or something like that. And it's to everyone's benefit in the premises. You know, you might get the classic example of the new lift and the all the common parts are being done up. And then completely other end of the spectrum, you've got this where there is absolutely no benefit whatsoever to the tenant, save that you might, I suppose, say there are going to be more extremely wealthy people living in there who might buy your art. But you're going to have a lot of disruption. And I think if you see it as that's on that sliding scale, how do you treat that, the reasonableness and the balance between the competing covenants at that end? I think what Alan Steinfeld is saying is that the money factor is going to be more persuasive in turning something to be reasonable at that end. Whereas if you're in the other side, and also the tenant knew about it, and it's very much for the benefit of the tenant, you might not necessarily need to go down that route, because you might just say, well, actually, I've got my legal right to be able to do this, and you knew that I was going to do it. Does that answer?
Yeah. In a sense, I think the court's doing a bit of a sort of profit share.
Yeah.
By the back door.
Yes.
If all that's going to happen is a landlord will make more money.
Yeah.
And that's entirely to the detriment of the tenant, well, maybe the tenant should be compensated.
In a different context, there's some statutory support for that with the Access to Neighbouring Land Act, where if you've got non-residential premises, a term of the access order could be some premium element in favour of the burdened party.
Gary, just while I was pitching in.
Yeah, feel free.
Presumably, offering a rent waiver, be it 100%, 50, whatever the landlord pulls out in the air, that's not magic enough to, for example, give you largesse to then do your construction works, possibly taking a shortcut or not taking every reasonable step to do your construction.
I think that's absolutely right. And again, I think I'm going to park that, because I'm going to come back in another case to talk a bit about that and what my client did in a case called Jafari, and how they dealt with those sort of issues. Because I completely agree, it's not it's going to assist you, but it isn't necessarily going to be your kind of get out of jail card. Yeah. Right, let's go on to scaffolding. So the scaffolding here has been designed, it's been erected with little or no regard to the tenant's interest, just gone up. The tenant was shown a sketch plan, which was a different, a more sympathetic version, and that they didn't actually ultimately put in place. It enwraps the building. There was evidence that wasn't actually necessary. It made it look like the gallery was part of the building site. Vehicles were delivering material. They parked outside. There's a whole negative impact on staff morale. And the landlord didn't engage with the tenant to identify alternative strategies. So again, you are acting for a landlord and they're about to do some works. It is really a good idea for there to be some engagement with your tenant. And then in terms of the noise, again, complete lack of dialogue between L&T on those issues. And the court said, when you're dealing with a Mayfair art gallery, it's particularly important. Again, it's that, remember, there's the 19th century case, just the name escapes me now, where there's that the judge says there's a difference between Belgravia and Bermondsey. I think it's actually, I was just going to say that, that you took the words out of my mouth. I'm not sure. I think that gap's seriously closed. But yes. I mean, if the judge came back now 150 years later, I'd probably be quite shocked. So again, I think that what the judge was also saying is experienced contractors should be able to know and anticipate what works are likely to be noisy, when those noisy works are likely to take place, and try and work around it so that the customers could come in at certain times. They might not necessarily work the normal, say like the sort of 9 to 5, 9 to 6 day. Work ahead statements in that case were only provided after the works were commenced. So again, almost, it's one of those classic examples that if it could go wrong and if it's exactly how not to behave, and damages there were awarded at the rate of 20% of the rent. And I think a lot of people have looked at Timothy Taylor and sort of said that 20% has become a kind of benchmark. I don't think personally that it needs to be considered in that way, and I think that each case really should be considered on its own particular merits. And there is no actual, I don't think that sets anything in stone in terms of a legal principle.
That's surprisingly low in the extreme circumstances.
Well, I think it is relatively modest, and you'll see in the next case, my client, not actually before I was even involved, actually decides to give a complete rent waiver, which has a serious effect in terms of the judicial thinking. And I do wonder if they'd only given 20%, whether that really would have been enough. So yes, I think 20 in those circumstances a little bit mean actually. Right, so I called this one when the pneumatic drill's worse than the dentist drill. Sorry, so if anyone's phobic about dentists, I should have said, given a trigger warning and said, look away now. Right, Jafari. So this is a case in 2019. My client owned a building in central Brighton, and part of the building was occupied by the tenant and his dental practice. My client wanted to redevelop the whole rest of the building, they were developing it to turn it into a hotel. And scaffolding was put up in February of 2012. It remained in place when the first contractor went into administration. Now, during the first period of works, there were noisy works without discussion. Second period, they got better and there were noisy works, but they were limited to certain times. Now, my client's agent had the foresight to say that this should be on a rent-free basis throughout the whole period of the works. And even though there was all of this going on with the administration, notwithstanding, and they just left the scaffolding up for 9 months whilst they found a new contractor, it was rent-free throughout that whole period. Well, the parties at trial agreed to follow the principles of Timothy Taylor. But here, and this is really the point we were discussing, Paul, just before, the works were primarily for the benefit of the landlord. And the trial judge said you need to look at whether the landlord has taken all reasonable steps to minimize disturbance. And one of the significant factors here was the generous financial compensation that was offered throughout that period. And that, again, was a very significant factor in the thinking. It was His Honour Judge Alan John's case here sitting in the Chancery list at Central London County Court. And he also, Dr. Jafari, on just an aside, it doesn't really go to the issue that I'm talking about here, said that my client had destroyed his practice and that had caused him loss of in excess of £1 million. But what the judge actually also said was that there was no causative link between the works and the lost profit. And actually, I think there is a point that I want to draw out here, which is that you often get clients who, when they hear there's this noise, there's dust, there's the vibration, scaffolding, they're going absolutely crazy about it. And they're saying, you're destroying my business, you're having such a significant effect. But actually, it's always worth reminding them that were this matter to ever get inside the courtroom, the judge will expect evidence. It's no good just making assertion. You need that evidence of that actual loss. And can you really show, and can you show the causative link? So on an appeal, again, the appeal was before Mr. Justice Nugee again, and he examined the factual matters. He said they were findings of fact, that he wasn't going to interfere with the appellate courts, as an appellate court, wasn't going to interfere with the trial judge's findings. And the finding that 100% waiver of rent was sufficient to offset the inconvenience to Dr. Jafari, again, he said that wasn't one that he could say no reasonable judge could reach. And then went on to say that even if the judge should not have taken into account the rent waiver and gone ahead and actually awarded damages, it was implicit in any event that the waiver of the rent would have been adequate compensation. So you get to the same result. So let's have a look at how, now that we've looked at these cases, how does the court assess reasonableness? What are the premises being used for? The location, the rent, the Belgravia Bermondsey Point, but actually I think the Mayfair Art Gallery, or say we were dealing with something on an industrial estate, might be treated very differently. The scale of the development, the value, the length of the works, and then this key point, who's getting the benefit? It's what you're saying, almost like the profit share. When did the tenant know about those works? And what level of dialogue has there been throughout, well, before the works and throughout? And have alternatives been explored? Have mitigation measures been explored? Again, looking at some of these cases where actually in the Gold Mile, they'd actually said, fine, we'll push the works back 6 months. We'll try to make it as pleasant for you as we possibly can. And has there been a rent concession? I think all of those factors are ones that need to be considered, particularly if you are acting for a landlord who wants to develop. Now, Paul is going to now tell us a bit about Tejani, where a lot of these issues all cropped up, but in a slightly different, because in the residential context.
Our Tejani case went to trial just over a year ago. It was quite an amusing case, in which we acted for the defendants. The facts of that case were that the claimant bought what should have been, and indeed frankly was, a very nice flat off plan under an agreement for lease in 2012. The flat was then built over the course of the next 4 years, and it was ready for Mr. Tejani to move in, I think it was May 2016. The price that he paid for the flat was 2.595 million. As soon as he moved in, or more or less as soon as he moved in, he started complaining, as did various other people in his family, about a curious noise that was coming from the facade of the building, which was described as popping or creaking or cracking, and which we formed the view was probably coming from overlapping plates on the exterior of the building heating up in the sunshine, and passing over each other and causing friction. So what he did was he sued. He sued the developer of the building under the agreement for lease, and he also sued the landlord and said that he had a cause of action in covenant for quiet enjoyment, nuisance, and negligence. He rather ambitiously initially said that his flat was uninhabitable, which was an argument that was never really going to work, not least of all because he appeared to be living in it. And he equally ambitiously said that the flat was worth nothing. He said it was completely unsellable, which was an equally silly argument because, amongst other things, he received an offer from an interested purchaser in the sum 2.8 million. He had better points. He sought rescission of the agreement. He said that he had a claim for 4 million in damages, being presumably the 2.595 million that he paid, plus, I think, unliquidated damages. He also said that he had a claim for lost rental income. One of the things that he said was that he was intending to rent the flat out under assured short-term tenancies and make some money that way. These, I think, are a useful summary of key points to take out of this case, and I think probably most nuisance cases. The first thing that occurred to me was that it is obviously a good idea to actually go, if you're a landlord, to go and see the problem or to go and hear the problem. I know that sounds very obvious, but I also know that there are cases in which landlords don't do this, and in which their lawyers don't do this soon enough, and instead they ask people what their experience is, and they might send a sound expert without actually even going. I think it is a good idea to go and see the problem, because you get a feel, obviously, for how big a problem it is, and you can sometimes start to realise that actually the problem that's being complained about probably isn't the underlying issue, and that there may be other problems with the relationship. The second point, as Gary has said, is be reasonable. We were reasonable. We took any and all, when I say we, I mean the landlord in our case was reasonable. They took any and all complaints, no matter how trivial and strange, very seriously. They sent people down. There was a lovely paper trail of the landlord trying to get access to the tenant's flat in order to go and hear the noise firsthand. And there were some instances of the tenant rather unhelpfully refusing access, which I think probably actually was very useful to us at trial. My third bullet point is be realistic and make offers. We did not take the view that landlords sometimes take, that the tenants' fairly obviously trivial in places complaints deserve just a stiff response. The landlord did make offers. The landlord at one point made an offer for unliquidated damages calculated at about 20% of the notional rental value, and they were completely ignored. And again, when it came to the costs argument at the end, that was understandably helpful. I've said underneath that, consider tactical gains that can be made in directions. Again, forgive me, a statement of the obvious, but worth considering whether you can gain a cheeky advantage. We gained a cheeky advantage. The problem being caused by heat and sunshine, and in particular, I think heat, was one which was more acute in the summer than the winter. And the timing of our directions or our first hearing allowed us to suggest, on the basis that expert evidence would be particularly important in this case, that it might be a rare example of a case in which experts should go before witness evidence, which was quite helpful because it meant that the sound experts went to the premises in January instead of July. The other side agreed to it. The sound evidence was very helpful to us and not very helpful to the tenant, and it led to an equally amusing last-minute attempt to remedy this, whereby the tenant sent their sound expert back without permission, although they did subsequently ask for it, to take further readings on the 20th of July, which was quite literally the hottest day ever. And didn't really come up with very much. So that was quite fun cross-examination. I think you might have asked him just to confirm that it was the hottest day ever recorded and that there still wasn't much of a noise. Get good expert evidence, by which I mean we had a very good acoustician who produced a wonderful report. His first draft was full of measurements and statistics and references to various guidelines as to what people might sensibly tolerate. What it didn't have in it, and we asked him if he would feel comfortable doing it, and he did, was a comparison of the strength of the noise with ordinary everyday things. And because it wasn't a terribly loud noise, and because it was quite infrequent, it was a couple of clicks, I think, every minute, he was able to say that the noise was comparable to the tapping of a keypad, and in one instance he said it was comparable to somebody loudly turning the page of a book, which all of which, of course, doesn't really feel like very loud noises. And he also was therefore able to have a lovely page in which he actually illustrated this with a series of images. So we had a picture of somebody in a library turning the page of a book, which the judge quite liked. My final point here is ask the judge to listen to the problem or see the problem. This again was an idea that actually hadn't been raised by the claimant in our case. It was raised by the judge. She said she wanted to hear the recordings that have been taken by the acousticians, which I think makes perfect sense. And our opponent suggested briefly that that would be practically difficult and possibly legally problematic, and the judge's face fell because she wanted to be helped. It was a good idea for her to listen to it. Again, it led to an enjoyable moment when she listened, I think, to 5 versions of the recording played at slightly different decibel levels, the loudest of which was 45. And she had somebody marshalling next to her, a student. And when it was played on the second loudest setting, after the recording had finished, she turned to him and whispered, but we could all hear it. I think I heard it that time. Now, if you're a tenant, again, I begin with get the lawyers to go and actually see or hear the problem at the outset. In our case, that hadn't happened. I know this because, having dropped some papers, I went underneath the bench in court at the end of the first morning to pick them up, and our opponents didn't, I think, realise I was still in the room. Well, yeah, that's one way of looking at it. And one of them played the noise to the other ones on a recording device. And the response afterwards was, quote, "Shit, that's not very loud." So go and hear it. I came out from under the bench once that sentence had been uttered, and there was a small amount of fuss, none of which was my fault. Again, if the landlord wants to investigate or try to fix the problem, be reasonable. Mr. Tejani, like I say, was not always reasonable when we attempted to fix the problem, and that bit him. Be realistic as to prospects and quantum. His claim was hopelessly inflated, in particular on unliquidated damages, which I'll come to at the end of this talk. He didn't consider any of our offers, which again just simply made him look unreasonable. There were open offers from the landlord in correspondence to him during the 3 or 4 years that he was complaining, or offering various financial incentives, and they just weren't considered. The case was carelessly put. For example, the idea that there was a loss of rental income didn't really make sense, because in other places he appeared to suggest within the same pleading that he intended to live there. These are the sorts of mistakes that I have seen in other nuisance cases. They can easily be avoided. And the difficulty that he had was that when he, for example, amended shortly before trial so as to remove the idea that the flat was uninhabitable, it just started to unravel for him. His whole case looked as if it might have been made up, at least in part. He didn't keep a diary or any notes or recordings of the noise. This was deeply unhelpful to him. He produced witness evidence from him and his family saying that occasionally they were woken up and describing it. But if he'd had a log over 4 years with frequent entries saying, "I woke up again last night, this is a real nuisance," that would plainly have been better for him, but they hadn't done that. He also didn't really have enough independent corroborating witness evidence. He had, as I say, evidence from his family, but they arguably had a vested interest. He had a witness from the flat upstairs, but it actually emerged that the chap in the flat upstairs also really wanted to sell his flat and fairly obviously thought this was a way of trying to extort some sort of financial compensation in circumstances where he couldn't sell. It just didn't really work. And his expert evidence also, in places, his expert evidence was very good, but it needed to be checked more carefully, because buried away in his acoustician's report, for example, was a statement that he didn't think this noise would wake you up. And we thought that was quite important. So I appreciate that a noise during the day can be annoying, but if it's waking you up, then I think you're into a whole different level of damages. The remedies that you typically find in these cases, the obvious one if the nuisance is ongoing, is injunctive relief in order to put an end to it, or specific performance in the same terms. You can and ordinarily might plead damages in lieu of injunctive relief as a fallback, the idea of the hypothetical negotiation under which the wrongdoer is permitted to do what they've done. In reality, that tends, in my experience, to be less frequently invoked than just injunctive relief and damages. You obviously may have liquidated damages. For example, there may be physical damage to the premises which you've had to fix. There may be lost rental income. There may be lost profits if you're a business. And then I finish by coming to unliquidated damages, which is an area in which I think people quite often overstate the amount that they think that they can recover. There are a couple of basic points. As I said at the beginning, that one thing that's important to remember is this is a tort to land. So when we're talking about unliquidated damages, we're not looking, as one might in personal injury, to the actual experience of the person in particular who's been on the premises. That is relevant, but it's not their subjective experience which quantifies the loss. The loss still has to be foreseeable, and there is still a requirement to mitigate the loss. There was a hint of a suggestion in Tejani that somehow the law of nuisance may not require usual mitigation principles. That's wrong. It does. The starting point when you're looking at damages is, has there been a diminution in value to the premises? There is obviously unlikely to be any diminution in value to the premises at all if you're talking about a nuisance that has actually stopped. If all you're talking about is a period of time during which your enjoyment was interfered with, then you are far more likely to find yourself simply bringing a claim for loss of amenity value for the period of the nuisance. The only person with that claim is the person who's actually entitled to possession. There have been suggestions in previous cases that if there were, say, 15 people living in the subject premises, then the amount the claimant might be entitled to is all the greater. That is wrong. The damages have been described as being incapable of being assessed mathematically, which is plainly right. The way that it's usually done is by reference to a notional reduction in what I've called the theoretical rental value. The courts have been at pains to point out that it doesn't have to be calculated that way, but in reality it frequently is. And it's not easy to see alternative sensible ways in which one might do it. And I've said here, be realistic. And I've cited the case of Dobson and Thames Water Utilities, because that, I think, is quite an instructive case. It was a case in which various people lived next to a sewage plant, and there were problems at the sewage plant, and the result of this was that they suffered from a smell which was described by the judge as vile, and they also suffered from mosquito bites because there was a big mosquito problem. And some of the people who lived in these houses lived there for periods of up to 10 years. And the resulting awards were between 1.25% for people who had lived there for, say, 2 or 3 years, and up to 5% for the people who'd lived there for 10 years. And I think it's worth remembering that, because awards, I've said, are rarely more than 10%. 20% is perhaps a better figure.
Oh, sorry, that's 10% of what?
10% again of the notional rental value of the premises. We saw 20% earlier. I think if you're making an offer, then 20% is a safe offer. But the idea that it would be more than 20% is not as frequent as people think. Again, in Tejani, there was a suggestion that the damages might amount to 60% of the notional rental value. It's just plainly fanciful.
If the premises are rendered by the defect or problem so as to be unlettable and indeed unsaleable, posit the instance of defective heating system, so defective that a gas safe certificate is not available, and that pertains for a long time, or egregious water ingress, the property is not lettable and it's not saleable. Where do you begin to assess damages there?
Well, if it's not saleable, then you've got, I think, the diminution in value point, haven't you? So I described that as the starting point, and I think in your scenario, it would be the end point. I don't see how you would. Well, I suppose you could claim both. I mean, if your intention had been to let it and you can't, and the result is that you also have an unsellable asset, then you would, I suppose, claim both. But the starting point, as I say, would be the diminution in value in that scenario. That's the end of our talk.
Are you able to just flip back one slide?
Yeah.
So second line, requirement to mitigate loss.
Yeah.
With a recollection, as my colleagues know, my recollection is really sound. But I have a recollection that Michael, in the Fern case, the early days of the Fern case, was quoted, possibly in the Guardian, don't know, that the solution was for the owners or the residents in the block flats to buy some curtains.
That was Anthony Mann's point in the first instance decision.
But where's the line in relation to mitigation? So I have another case, my own case, about a sound problem.
Yes.
And the respective clients were proposing to put their own sound insulating material within their own flat, despite the fact that they were being disturbed by their neighbours who had undertaken alterations that they caused. There was then sound disturbance. Is that something that, to go to that extent where they're installing their own sound insulation materials in their own flat, despite being the people disturbed?
Mm.
Is that too far? Or are they just being, is it too much? Or could they be required in the context of mitigation to do that sort of thing? Where's the line?
I think the line there would very much depend on the cost of that and how cumbersome it was. So, I mean, if we're talking about a step that you could take that was going to be a matter of a couple of £100 or something, and it was very easy and quick to do, that would be very different to expecting someone to spend £20,000 putting in some insulation, which I think would be too far, even if one was living in a very expensive property. I don't think that could really be expected of somebody. Why should you have to go off and do that? It may also be, say you may have to open up walls. You may have to. It may not be very aesthetically pleasing. You may have to redecorate. There could be all sorts of things. Why I would think that a judge might take the view that wasn't a step that had to be taken.
Carry on.
Yeah.
I started saying client and then I corrected myself and said prospective client.
Yes.
And the reason I said that was because in fact it didn't convert, because we talked about costs and so on, and the potential uncertainty working out whether there in fact was an actionable experience of some sort. And when we started talking about some uncertainties around that and the costs that I was going to charge just to have a look at it, they thought actually 20 grand for putting in the sound insulating material within the apartment was better option for them because it would give them certainty of outcome quite quickly.
Well, that's just a sensible price, and that's what I often tell clients when we're sitting in the mediation. I say, whatever the cost is, it's the price for certainty, and that's just a sort of an even earlier example of that. Yeah.
You say anything be a nuisance, which is kind of what if it's a nuisance to land.
Yeah.
It's kind of what seemed to be the main point that came out of Fern, not that they massively rewritten around nuisance. It's more that it expanded it slightly to say something like this.
Yes.
For nuisance. Would that, for example, involve if you had a property which, and I'm sorry, I can't think of a practical reason as to how it would happen, but for example, a property that stopped another getting Wi-Fi, for example, given how important that is to most people these days.
Well, of course, in the Hunter case, which we started off with, those were the blocks of flats in Canary Wharf, and they lost their as a result of the development, they lost their TV reception. The court said that wasn't a nuisance, but
You didn't say that necessarily. So you don't have an entitlement.
Yes, that's it. You don't have an entitlement. Yeah, exactly.
Sure
I know that's right. Yeah. Now, would nowadays, because I've thought about this myself, I mean, if you couldn't have Wi-Fi, you couldn't watch Netflix, you couldn't, you couldn't surf the internet, you couldn't do, I mean, all the things that we do that require Wi-Fi. I think that would be a point that would be worth pushing and testing if there was a development that did that. The thing is, nowadays there's probably a much easier technical way around that problem anyway. So it's probably it's probably unlikely to kind of happen in quite that way. Yeah.
I said that where a landlord is planning on redeveloping the building, the kind of offer for compensation that it makes is relevant to decide whether it's being reasonable. So if you're offering from the outset compensation, percent the rent. What if what you're saying as a landlord is we're going to do these buildings, we're willing to, you know, give you 20% off the rent, but what we want is you to sign this document saying you're giving us a blank consent to the works. Is that still an offer of compensation? Is that still relevant? Or are you asking for too much there as the landlord?
So the landlord enters into an actual side agreement with the tenant.
Yes, you know, normally, yeah, but I would have thought that most of our clients will want some kind of offer of compensation to be tied to some kind of certainty.
That happens all the time. So, you know, people enter. I mean, I've had I'm not going to go into the details, but a very large development in the West End where we ended up having to enter into neighbourly agreements with all the neighbours around it. Effectively, one's buying them off, and I mean, there's not the landlord and tenant context. It's the neighbouring context, but there's no reason why in the L&T context that couldn't work as well.
But yeah, the question is that still an offer of compensation? Is that still relevant? You know, is that still relevant? If when they say no and take you to court, can you still say that we offered them compensation? Or are you?
If it was on an open basis, then I don't see why not.
It's identical to buying off rights to light.
It's just you're not offering to compensate them really, but you're buying an ability to do your work.
Landing on Ed's points, if you've got a brand new lease, landlord anticipates they're going to be doing landlord's works in the next 1 to 2 years. If there's a provision in the lease which prioritises the landlord's works over the covenants of quiet enjoyment, makes it clear that no claim can be brought for nuisance, would that let you off the hook entirely?
But not if personal injury could be caused by the nuisance. Is that possible? No, you're saying it can't be possible because it's
taught to land. But I think if, in theory, yes, but I think probably again within confines. So if, let's imagine that you'd reach that agreement and you stick to, and you've already set out very clear ideas and plans of what's going to be done and when and how long it's going to be for and what hours and all of that, and you stick to it, then I suspect that would preclude any claim. If you then go outside that, not only could you, I suppose you could run a breach of contract argument as well, but I can't see how you could have fettered the right to then bring a nuisance claim if you know there was all this terrible drilling and vibration and noise that went beyond what was anticipated.
I think
it's going to be quite fact specific.
Steps in there, those parameters, then you're on safer ground than just having a carte blanche shield.
Yeah.
I think as well as the transfer of money, which often we're saying it can the difference is about the communication, because some of those cases arise from situations where people thought they knew what was going to happen at the start, and then someone goes into administration or there's an accident or something, and it takes longer, maybe much longer than it was originally going to be. And so probably part of the workaround, so even in your situation where you think you've nailed down what it is, if something changes, then you might need to talk about it, and that might involve some sort of uplift on what the original deal might have been to reflect the reality of what was originally contracted.
I think that's a very sound point, and it really goes to that heart of the idea of the dialogue and continual dialogue, and the more dialogue that there is between the parties, the safer particularly the landlord's going, you know, is going to ground for the landlord.
One silly question.
Mm.
Was Tejani for the two of you the most fantastic fun?
It was good fun actually, because it's one of those rare cases. Now, you know, don't get that many in property litigation, but it was one of those that ended up in the Sun and the Times. We actually ended up in last year. I opened up the Times, the Saturday magazine, and they do a quiz every year. And we were one of the wrong quiz answers. And the right answer was the what was it? It was one of the privacy cases. Can't remember if it was Prince Harry or something like that. Something like that. But I thought, right, well, that's great. I haven't framed. I cut it out, but I haven't framed it. But so that was a lot of fun, and I mean, I think there were some very. Our client there was actually a pension fund, and they, for anyone who's acted for that sort of client, they know they're actually very conservative. They do not really want to be in the courtroom, and they want to take as many steps to make sure they don't need the publicity. They don't need, I mean, actually, even though it's an SPV here, they don't need all of that. It's hassle for them, and I think that they took a lot of steps to try to bend over backwards to get rid of that case. And it was a classic example of someone, Mr. Tejani, who was badly advised and has a completely deluded view of the world. And so when it comes to that, yes, on the one hand, it is very funny. Actually, there's actually a bit of sadness in there, actually, because one ends up feeling slightly sorry for him, because he was actually a bit pathetic in the witness box, because he's been led on by his son, who was, I think, really, again, going into the whole psychology. I'm not a psychologist, but the son had been handed over the sort of family. I think the family business, really. They'd made their money in loo rolls and tissues, and I think he kind of was told, right, you get on and buy this and we'll sell it and we'll make a fortune. And it didn't work out. And so I think he was looking for any old excuse. And then suddenly they'd managed to convince themselves that this noise was so bad that the property, as Paul said, was worthless.
Have you any idea to what extent his solicitors tried to advise him against that or to scale back?
That's also very interesting as well, because he went to one of these people who's actually a barrister who set up a litigation boutique. I won't say who it was, but the man also had his own litigation and also owns a couple of these expensive flats in this is the development that's the former Middlesex Hospital in off Mortimer Street. It's now called Fitzroy Place. It's a very, very expensive flats, and he owns a couple of them and had his own dispute about other issues. So I think it was all tied up with I think they were all encouraging each other.
Short answer to your question was yes, but it was because Paul was skulking around other offices.
Yeah. Exactly.
Yeah.
Exactly.
Yeah. Yeah.
Was Mr. Shine the only putative claimant against the? I suppose there's no way of knowing, but presumably not.
No, there were others again, sort of waiting in the wings. There were a few others who wanted to see how he got on.
Yeah. Were they successfully compensated and made to walk off into the sun? They just kind of.
I think they were waiting to see, and I think they disappeared from memory.
They just stopped complaining.
Yes. Yeah. Yes. And what's very interesting in that sort of case is that the costs certainly sobers up people's their enthusiasm, because Mr. Tejani, I don't think it's been completely resolved, but I think our costs were in excess of 800,000, and he had to, he's got to pay a very significant chunk of that. So.
Is that an indemnity cost?
It wasn't actually. No, she actually ordered it on standard costs. Yeah, of course, nowadays with cost budgeting, you can still get back higher than you used to be able to. Right. Well, if anyone else got any other questions, I'm very happy to answer them. I'm sure Paul is, or if anyone just, thinks of something at a moment of insomnia or something, just pop it in an email or whatever to us.